I'm glad to be joined here by Susanne Willems, Senior International Tax Advisor, and Kyra van Denken, Labour Lawyer and Employment Advisor from Baker Tilly in the Netherlands. We hope this webinar will interest recruiters who operate in the Dutch market and contractors who work or plan to work there. Our primary focus here is on employment, as traditionally this is the status of most contractors from abroad coming to work in the Netherlands. We've got an accompanying video which you can find a link to on freelancing in the Netherlands, which is the ZZP route. Now, if you've got any questions, please post them on the Q&A, and if there is time, we'll try to answer them. If we don't have enough time, or if the question is specific interest to you, then we'll answer you in writing as soon as we can. We're mindful that you're all busy people, and we want to take as little of your time as possible, but still pack in as much useful information for you to take away. So with this in mind, let's press on. So in the Netherlands, what is the Flexicurity Model? In the Netherlands is one of the originators of the Flexicurity Model alongside Denmark. So let's examine what the Flexicurity model is. The main principle is to balance flexibility for businesses with workers' security. Employers have more freedom in hiring and dismissal compared to stricter models. There's a prevalence of temporary contracts and part-time work. So the security encompasses three main areas, which are generous unemployment benefits that support workers financially while searching for new jobs, a strong safety net that provides healthcare and other social benefits even during employment and unemployment, and comprehensive retraining programs help workers develop new skills to stay competitive in the labour market. The legal background of the Dutch Flexicurity Model is enshrined in the Flexibility and Security Act of 1999. The goal is to normalise non-standard work, meaning temporary and part-time jobs have similar rights to full-time positions regarding social security and working conditions. In other words, to extend the rights of gig workers to be the same as those engaged in full-time employment. So what are the benefits of the Flexicurity Model for business? Well, there are several advantages for businesses, and these include the prevalence of temporary contracts and part-time work. It allows businesses to scale their workforce up or down more readily in response to fluctuating market conditions. The flexibility is crucial in today's dynamic business environment. The model can potentially lower recruitment and onboarding costs compared to filling permanent positions every time. Businesses can leverage temporary workers for specific projects or peak periods without the long-term commitment. Temporary work arrangements, they can attract a diverse talent pool looking for flexible work options. This allows businesses to tap into specialized skills or fill temporary gaps without a full-time commitment. Studies suggest that a well-designed flexicurity model can lead to increased employee motivation and productivity. This can be due to factors like a more efficient use of labour and a focus on matching skills to specific tasks. So how do you address the two-tiered labour market? Well, strengthening the transition to permanent contract, lowering the threshold for temporary workers to qualify for permanent positions, offering a more robust training and development opportunities for temporary workers to increase their chances of making this transition, standardising the benefits for temporary workers. So providing temporary workers with benefits closer to those of permanent employees, such as pension contributions or sick leave entitlements. And this could be a tiered system based on the duration of temporary work. So improving job security for temporary workers, limiting further the number of contract renewals for the same position, and exploring alternatives like project-based contracts instead of consecutive temporary contracts. Enhancing worker security and training by investing in broader skills, offering subsidised training programs for all workers, regardless of employment status, to help them stay competitive in the job market. strengthening the role of unions, allowing unions to play a more significant role in negotiating better working conditions for temporary workers. And this could involve collective bargaining agreements that apply both to temporary and to permanent workers. So finally, improving enforcement of labour regulations, increasing the resources for inspections to ensure businesses do comply with the regulations regarding temporary work. Then balancing the flexibility for businesses, streamlining admin burdens, simplifying the process for hiring and managing temporary workers to reduce the admin costs for businesses. Providing incentives for offering permanent contracts. There are tax breaks and other incentives for businesses that offer a higher proportion for permanent positions, more advantageous to take people on long-term continuous employment than temporary contracts. And promoting best practice by highlighting successful examples of businesses that use Flexicurity Model effectively to attract and retain talent. So finally, continuous monitoring and evaluation, regularly assessing the effectiveness of the Flexicurity Model and making adjustments as needed. And then finally, to have a dialogue between all the stakeholders, encouraging ongoing discussions between businesses, unions and policymakers to find solutions that benefit all sides. Now, the next topic is the Wet-Arbeitsmarkt in Balance. What is the Arbeitsmarkt in Balance, or the WBA? So in the context of the Flexicurity Model, the Wet-Arbeitsmarkt, and I apologise for my Dutch here, in Balance, is the Dutch law for a balanced labour market. It came into effect on January the 1st, 2020, and it replaced a number of older laws relating to employment contracts and temporary work. The WAB introduced a number of far-reaching changes and tweaks to the existing law as it affects those in temporary positions or are gig workers. The main changes that the WAB brought in include the following. Employers are limited in the number of times they can renew temporary contracts for the same position. After a certain period, under temporary contracts, the employee has the right to transition to a permanent position. Employees have the right to request predictable work schedules and receive compensation for unpredictable schedule changes. The employee is entitled to the transition payment upon dismissal from the first day of work. The calculation of the transition compensation has also changed. And the WW premium, it's more attractive for employers to give employees a permanent contract. Since 2020, employers pay a lower WW premium for employees with a permanent contract than for employees with a flexible contract. So we can see that the WAB is part of the broader Dutch Flexicurity Model, which aims to balance flexibility for businesses with security for workers. Now, one aspect that has a particular effect on temporary working engaged with a payroll company is that employees must be offered what is called an adequate pension. And this is so since January the 1st, 2021. Now, this refers to payrolling, a special form of provision of personnel, where the payroll company is the employer of the payroll employees, but they work for the hirer. The payroll company is effectively the lender. The payroll employer assumes all the employer expenses and relieves the hirer from these things. Among other things, the payroll company takes care of the payroll and the wage payments, employment contracts, and the pension accruals. An adequate pension is a replacement for the old system, but the level of contributions is now set at a relatively high level of employer contribution. This change in legislation, it aims to improve and equalise the position of payroll employees in the labour market. Now, the next topic is what has happened with the EU Directive on platform workers. Now, the EU has been trying to introduce a new directive, an EU Directive on platform workers, which, once implemented, it's going to be an obligation on all member states to introduce into their domestic law. The premise is that job seekers who find or hold a job via an electronic platform will be deemed to be employed by the platform operator. This concept is very new and quite radical. The directive, also known as the Platform Work Directive, or PWD, has been on a bit of a roller coaster recently. And here's a brief timeline. It was originally proposed in December 21, and it aimed to improve the working conditions and address the misclassification of platform workers as self-employed. A provisional agreement was reached in December, but it fell apart shortly afterwards because of disagreements between member states. Negotiations restarted in January 24 under the Belgian presidency of the Council. And on March the 11th, 2024, final agreement was confirmed, and this means that the PWD will be implemented. And it's going to improve working conditions for platform workers, regulate the algorithms in platform work, and increase the transparency and give workers rights to contest automated decisions. So after some back and forth, the PWD is finally moving forward and is expected to bring significant changes to the working lives of platform workers in the EU. The final definition of a platform under the EU Platform Workers Directive isn't publicly available yet. However, based on discussions and the originally proposed definition, here's what we can expect. It provides a service at least partly electronically. So this means the platform operates through a website or mobile apps. It connects workers and service recipients. So the platform acts as an intermediary, matching individuals offering services to workers with those seeking them, the recipients. The organization of work is a necessary and essential component. So the platform plays a significant role in structuring and managing the work performed by individuals, not just facilitating communication. So the other considerations that we have to bear in mind, the platform may be a natural or a legal person. It means it could be an individual or a company. The service may be provided commercially or non-commercially. So this captures both platforms operating for profit and non-profit organizations. Work can be performed online or offline. The platform may connect workers for tasks performed physically or virtually. So here's why the final definition might not be publicly available yet, because the final agreement was reached only on March the 11th. And the implementation process, the members now, they've got a period to convert the directive into their national laws. And this process may involve further discussions and legal refinements. So while the final details of the EU Platform Directive aren't publicly available yet, we can look at the proposed exemptions from the original directive to understand what platforms offering services with similar characteristics might be able to avoid classifying workers as employees. So here are some potential exemptions from employee classification, I should say. Not-for-profit encyclopedias and research depositories like Wikipedia or research databases, they're not going to be obligated to classify contributors as employees. Open source software development platforms like GitHub, where developers collaborate on open source projects, likely won't be considered employers. Online marketplaces, platforms facilitating sales between individuals or businesses like eBay, they won't be responsible for employment classification. Telecommunication networks, providers won't be obliged to classify users as employees for simply using their network. And private or B2B cloud storage services, providers like Dropbox, they won't be responsible for user uploaded content or potential work performed within their storage space. So you're going to have to bear in mind that the key factor will likely be the level of control and organization the platform exerts over the work performed. Platforms with minimal involvement in task management won't be classified as employers. Platforms that connect true independent contractors who manage their own work schedules and tools, they won't be responsible for employment classification. However, the definition of independent contractor may well be scrutinised under the PWD. So there are exemptions based on the proposed directive. The final details, including the specific wording and interpretations, might differ in the official version adopted by member states. So what we need to look for in the coming months are official announcements from the European Commission or member states regarding the final exemptions list under the PWD. We may see legal analyses clarifying how the exemptions apply to specific platform business models. We may see platforms talking about their uncertainty about their own classification. And there will be consulting and legal counsel going on, people specialising in labour law in the UK, in the EU. Talking to these people we recommend very highly, because they can analyse the platform's operations and advise on potential implications of the PWD. And there will be criteria published. There will be criteria that you'll have to meet in order to avoid this categorisation. So overall, it remains to be seen how job boards and other similar platforms will react to these changes, but it will certainly involve them in classifying workers in each job role and employing them if caught by the definition. The risk of deemed employment, should the classification be disputed by the authorities, in this case the Dutch authorities, will encourage platforms to tread cautiously and assess whether they wish to be drawn into these responsibilities or not, and many may decide this is a bridge too far. So briefly, returning to something I mentioned earlier, the employed model is one contractor option, but viewers should be aware that self-employment is a widely accepted alternative in the Netherlands, and we go into detail about its advantages and disadvantages in our ZZP video. So self-employment, or ZZP, is not a legal status, but an employment one, and it can be achieved via one-man sole tradership, a partnership, or through the use of a limited company. But for more information about this, I do refer you to our video on freelancing in the Netherlands. Thank you.
I think it's my turn to go into some tax-related items. We try to keep it limited to items that could be relevant if you come from the UK to the Netherlands. This being said, the presentation will not be complete on the complete Dutch total tax system, but only the specific items we think are relevant and have some major changes. First, we want to go into the work-related cost scheme. In Dutch, it's the werkkostenregeling. The work-related cost scheme, it's a scheme that's quite familiar for foreigners, fortunately. There are various methods to determine how to calculate the discretionary scope. If you look back from the beginning, if you are employed in the Netherlands, you have, of course, your salary, that's taxable. And then the definition of salary in the Netherlands and Dutch tax legislation is quite broad. So it also includes certain advantages that you get from your employer. This could be a laptop. It could also be some employers compensate for rent, etc. All those items are included in the salary. And to determine how to tax certain salary aspects, we have the work-related cost scheme. As indicated, you have the discretionary scope. That's the vrije ruimte in Dutch. In 2024, it's 1.92% of the taxable wages, up to an amount of 400,000 euros. So simply put, if you have a taxable salary of 400,000 euros, you can have 1.92% of that salary sum can be used for non-taxed benefits for your employees. If you would exceed your vrije ruimte, your discretionary scope, then you have the final levy, the eindheffing in Dutch. The final levy is the wage tax, so there's no national insurance contribution, there's no healthcare insurance contributions due, but it's the wage taxation, and it's quite steep. So we always try to stay away from it, but simply put, if you have provided your employees with a big package at Christmas, it could be that you would exceed the vrije ruimte, the discretionary scope, and then a final levy is due. There's also, and I think that's the most important one, There are specific exemptions and zero valuations that are also part of the work-related cost scheme. And I'm going to go into detail on some of those, not all. Some of the specific exemptions can be travel allowances. So if you have travel cost from your house to the work address, that's a specific exemption, but also, and this one hopefully rings a bell, the 30% reimbursement ruling. It's also called the 30% facility, 30% ruling. I've heard many terms for it. Simply, at this moment, if you meet certain conditions, and we'll go to in more detail a little bit later, then you have a tax-free allowance that's equivalent to 30% of the gross salary, subject to Dutch payroll taxation. So, best example, if the gross salary is 100 euros, hopefully normally it's a little bit more, but if the gross salary is 100 euros, and you would apply the 30% facility, you only have to pay wage taxes over the 70 euros, and 30 euros is a tax-free reimbursement. It's no longer called a salary, it's called a reimbursement. It can only be applied for employees. So, as Kevin mentioned, in the Netherlands, the ZZP construction is a very common construction, but it does not work for the 30% facility unless you work for your own company. So there has to be an employment-employer relation. One of the other conditions is that it has to be agreed in writing. And I think that's the most important one. The employee must be recruited from abroad. And we have a 150 kilometer distance that you have to not meet, that you have to live more than 150 kilometers from the Dutch borders. So simply put, if you look at where Netherlands is located geographically, persons from Belgium would not apply. If you're in the UK, in most cases you would apply. I think there's 1 or 2 cities that's a little bit too close. So you have to look at the complete distance until the first Dutch border that you see. So not the main center of the Netherlands, but the first border that you would meet. There's also a minimum salary requirement, which is also important to keep into mind. And we'll go in more detail on that later as well for certain labor legislative changes. And the minimum salary requirement gives you an insight on the specific experience or expertise a person has. I say current situation. If I say something like current situation, we all get a feeling changes are coming. That's indeed correct. It's not set in stone yet, but there's currently a number of proposed changes to the 30% facility. I've put them below each other because there's different transitional rules, there's different timing. So let's just walk through it. It was already decided a while ago that as of January 1st this year, so 2024, the facility would not be applicable if your salary would exceed a certain amount. And in 2024, that amount is 233,000 euros. So if you have a salary of 250,000 euros on a yearly basis, you can apply the 30% facility up to the 233,000 euros. So the excess is no longer part of the 30% facility. If you already applied the ruling in December 2022, the cap will apply as of the 1st of January 2026. So there's a transitional legislation for persons already applying the 30% facility. They didn't put it in the sheets, but I think it's good to know that at this moment, the 30% facility has a period of 5 years. That's valid. So you have a 30% benefit for 5 years. Maximum, it could be less, of course, under certain conditions. The next change that was proposed, and that was proposed December last year, so it was really last minute. We had a lot of discussion about it, but really last minute. There's a proposal to decrease the 30% in the 5-year term. So they now call it like the 30-20-10% rule. In the first 20 months, you can still apply the 30%. In the next 20 months, you can apply 20% reimbursement tax-free. And in the last 20 months, you can apply a 10% tax-free reimbursement. Also, in this case, there's transitional legislation. If the ruling was applicable in December 2023, you can apply 30% for the whole full term that the ruling was granted by the tax authorities. So this could only have an impact if you would apply for the ruling as of January. There's another big change. At this moment, if you are applying the 30% facility, you are considered as a non-Dutch tax resident for other taxations. In the Netherlands, we have like 3 taxations. We have the first box, but I will go into some more detail. But in principle, you will be only taxed for your Dutch income. So any other income, so if you have like a house in the UK still, it's not included in your Dutch taxation. This to avoid that filing your tax return is very complicated and very difficult. This will no longer be the case under the new proposed changes as of January 1st, 2025. Also, in this case, we have transitional legislation, transitional law. If the ruling was applied in December 2023, so we see the same term with the decrease in the percentage, the Dutch tax regime can be still used until 31st of December 2026. I say proposed changes. At this moment, there was a lot of discussion because big companies in the Netherlands have pointed out that this method and this facility is very important for the Netherlands to get people with highly skilled or highly expertise in certain areas to the Netherlands. We're a small country. We need people from abroad. So they have gone to the ministry and they said, okay, this is not, you don't change this facility. At this moment, it is determined whether these proposals will actually be applied. It is current legislation. However, in September this year, September, we always have budget day in the Netherlands. New tax plans for the next year are proposed, and they have indicated that most likely a change to this legislation will be proposed as in September 2024. I would like to say, I don't think it will go through as it is at all. I'm not going to think that's the one. We hope that the 30-20-10% rule might be a little bit different, but we're still looking forward to getting more information. So it's not yet clear. So what happens if you would not first meet the requirements of the 30% facility, or what would happen if you would no longer benefit due to the changes? I always like to point it out because it is a possibility, but it's way less familiar with at least the foreigners I speak to. There are alternatives for the 30% facility. You can, as an employer, also, without any taxation, reimburse the employee for the actual, I'm always struggling with the word, extraterritorial expenses, so the ET cost. However, you would need more proof on what the actual cost would amount. What are actual ET costs? Simply put, think about double housing cost, moving expenses, cost of permits, especially important after the Brexit, since it's no longer possible to just come into the Netherlands if you're a UK resident, but also contributions for international schooling, potential language courses, etc. So simply put, costs that you make that are linked to the fact that you're moving from one country to another country, those can be reimbursed without any taxation. As indicated, the proof on this is way harder, so that is why in practice we normally see that people apply for the 30% facility, because then there's no burden of proof on the actual cost, so you don't have to show the mortgage payments on both houses, etc. So that's the biggest difference. You can also think about travel allowances. We have travel allowances, as indicated what I said, from your place of residence to your work, but you can also have travel allowances internationally. Of course, relocation cost can also be reimbursed without taxation if you relocate due to your employment. Those are not only applicable in international situations, but it also could apply in national situations. So if you move from the north of the Netherlands to the south of the Netherlands because your employer is located in the south of the Netherlands. You can also give your employees a working from home allowance. That's a specific amount that's calculated yearly, which is not that much, to be honest. It's like €3 something a day for cost that people make if they are working from home. Think about coffee, toilet paper, etc. It's all part of the the COVID measures. You can also provide office furniture for your employees. You can also provide it for them to be used at home. However, as of the 1st of January 2022, these are directly linked to the Working Conditions Act. The Working Conditions Act is, of course, legislation regarding the way people are allowed to work. So if you give people a desk, the desk should be it should meet certain requirements, such as you can modify the height of the desk so that you can modify it to your own length, those kinds of conditions. And you can also reimburse personnel for IT items, such as a laptop or a mobile phone. It's not as strict as it used to be. Another topic that we see in the Netherlands, which is not very familiar with foreigners, is the customary salary scheme. In Dutch, we call it gebruikelijk loon. This is legislation that's only applicable if you are a director or a major shareholder. In Dutch, we call it directeur groot aandeelhouder, also DGA for short. If you see it somewhere, we're pointing to director major shareholder. The customary salary scheme, het gebruikelijk loon, is put in place a while ago. We had a lot of persons setting up their own entities. Instead of working as an employee, they set up their own entities, work for their own entities or not, and they would have like management contract consultancy agreements with clients. It's a common way in the Netherlands. From a legislative perspective, there was nothing wrong. From a tax perspective, it was not really enthusiastic. The tax authorities weren't really enthusiastic about it, because simply put, normally if you're an employee, you would pay a yearly tax, and these director major shareholders could put off taxation until a very late moment, and in some cases they didn't pay taxes at all if they kept all the funds into the company. So we have the customary salary scheme. Simply put, the director major shareholder is obligated to calculate a fixed salary, and they have to pay wage taxes on the salary as well, and social security contributions. And to determine the height of the salary, you must apply the highest of 100% of the salary of a comparable job. I always give the example of an attorney. If you're an attorney, normally, at least in the Netherlands, it's not very likely that you would have an income of, let's say, €50,000. So the income would be much higher. So then the customary salary scheme should also be a little bit higher. The other one is the salary of an employee with the highest wage within the company or group of companies. You cannot pay yourself as a director less salary if you have an employee that has a way higher salary, unless there's specific reasons. But in principle, that's not likely. It's not logically, so they put it off. And at least the fixed sum should be 56,000 euros per year in 2024. And it's increased yearly a little bit. So we see it from 51 to 53, 50, 56. So it's a small increase. As indicated, on this amount, wage taxation is due. So you have to do a monthly wage tax return, and you have to pay the wage tax and social security contributions. It's a common mistake, but there's no standard reduction if you work part-time. So you cannot say, okay, the 56,000 euros is for a full-time employment and I only work like 50%. So I have a 20-hour work week, so I will take half. That's not how it's calculated. Don't ask me why it's not, but the tax authorities are very strict. It's not. Okay, how does taxation and social security contributions work? Because we always go into these details and then we think about, okay, but how does it actually work? We have the Dutch tax system. We have 3 boxes. We call it boxes. We have box 1, box 2, box 3. Box 1 is all the income from work and home ownership. And this, for us, is very clear, but to be complete, home ownership is the house you actually live in. So it's not the second house. It's not a nice cabin in the woods that you go to on holiday. It's the house where you're actually living in, so your main residence. Box 2 is income from a substantial interest in the company. If you are a shareholder in a company and you have at least an interest of 5%, then it's considered, any income is considered as box 2 income. And you have box 3 income, and I always say that's the rest, but it's income from savings and investments. So that could be a saving account. It could also be, as indicated, the cabin in the woods or the second house on a very nice beach or somewhere. That's taxable in box 3 in principle. Then we have certain tax rates. In the Netherlands, we do it a little bit differently, I think, than in most countries. We calculate our social security contributions in box 1. And if you ask a Dutch person the tax rates, they're going to say, okay, it's 36.9 and 49.5. They don't take off the social security contributions because it's so common that you have to pay them anyway. So they've just added them up. But if you look at it from a foreign perspective, there could be a difference. So I've set them out from 0 to approximately 38,000 euros. There's a taxation of 9.3%. And a big part is social security contributions of 27.65%. Those are the social security contributions, assuming that you did not yet reach your retirement age. The amount above until 75,000 euros is taxed against a tax rate of 36.9%, and anything above is taxed against a rate of 49.5%. So I'm not going to lie, the tax rates are quite steep, quite heavy, but still good to be in the Netherlands, especially if you're not subject to social security contributions, but we'll go into some more detail a little bit later. For the box 2, so the income from substantial interest, we have 2 tax rates as of this year. We used to have a flat tax, but this year things changed. So if you have a income, like a dividend income, from 0 to 67,000 euros, you pay 24.5%, and 67 until anything up, 33%. If you're married, then for this legislation, for this box, there are potential benefits if you file your tax returns as what we call tax partners. That also is the same for box 3, so you can shift income from one partner to the other, so there's a little bit of more room, and you can, and that's the best part, you can ultimately pay less taxes to the tax authorities, which is always the best case. Box 3, the income from savings and investments, that's a really, first of all, it's a really different one. Second of all, it's a really complicated one at this moment. Not the tax rate. The tax rate is flat, it's 36%. But you pay the tax on a deemed income. And the deemed income depends on the type of income. So if you have a savings account, the deemed income at this moment is quite low. It's like, I think, 0.01%. So that's okay. But the deemed income on a house or anything, even if it's just like your vacation house that does not generate any income at all, you still have the deemed income like a 5 or 6%. So, and we don't care about your cost, about your actual income. We don't really care. We just want the value of the object. So the total amount on your savings account or the value of your real estate, and that's taxed against the deemed income. At this moment, I think 2 years ago already, during Christmas is always a busy time in the Netherlands. During Christmas, there was legislation that said, okay, the deemed income that you're applying as a legislator is not fair for all persons. Because if you have just savings, it used to have a fixed income of like 4%. I think if at this moment somebody in the Netherlands has a saving account that has a 4% interest, it would be very busy because the interest is way lower. So they said the current situation, the current legislation is not fair. You have to compensate. And then things started to get complicated because the tax authorities really do not want to compensate. They have to because the judge said so, but they don't really have to. So they are looking for an alternative, which makes it complicated. At this moment, it seems, but I'm very hesitant with making a statement on this. At this moment, it seems that we will go to a taxation on actual income. And for certain types of income, such as over certain aspects, such as housing or real estate, they would say that a non-realized profit should also be taxable. So during the year, if your real estate increases in value, that increase should be taxable according to the tax authorities. Every time they come with a new proposal, they have new legislation that said, okay, great proposal, does not work, not fair, it has to go. So at this moment, it's really complicated to say anything useful against regarding the box 3 income. I think it's good to point out that this is, of course, depending on where, especially for real estate, where real estate is located. Because you have Dutch income, you have the worldwide income. That's also a big discussion, which is important. There were a lot of people in the Netherlands that are, we call them tax refugees, that moved to, previously, Belgium was a really attractive destination. So tax residency is a very big item. You see a lot of Dutch people, especially if people are getting of an old age, that move to Spain or Switzerland to enjoy living there. Portugal is also, UK is also a really attractive location. So residency is very important of tax purposes. So residency is determined on your center of living. So where is your friends, your house, your kids? Do you have any bonds with? Where do you go to the gym? Those kinds of things are also important to determine the tax residency. And the tax residency is important to determine how tax treaties in the Netherlands work out. It is important, of course, to determine if you are considered a direct or major shareholder, to determine if you're taxable for the customary wage scheme. So that's also important. And we have a big discussion on employees and self-employed persons. I think together with the whole wide world, we're discussing on how to go forward with that. It's also a big topic that we're following at this moment. I don't have a straight answer. but it is something that's important in the Netherlands to determine. In the video that Kevin refers to for self-employed persons, you will see that taxation is a little bit different than as for an employee, so there could be differences. If you're an employee and you look at the most Dutch tax treaties, taxation is in the country of residence. So normally, let's say you move to the Netherlands, it would be in the Netherlands. If you perform your activities in another country, it's shifted to that country, and it shifts back if you would not meet the 108, if you meet the 183-day rule. Very simply put, because it's a complicated legislation, but that's principle how it works. What are the potential outcomes? If you look at it from a Dutch resident, you could have your full salary taxable in the Netherlands, or it could lead to a salary split, which is a part of the salaries, part of the income, part of the salaries taxable in the Netherlands, and part is taxable in another country. Social Security contributions. I think the Netherlands is known that we have quite a good Social Security system. It's not the cheapest one. That's comes with the quality. For Social Security, also the place of residency is very important. Within the EU, and the UK works the same because we have a Social Security arrangement. The EU regulations are that you need to determine where the substantial part of the time is spent. There are some additional agreements that could be important. It was, after the COVID situation, very hard to determine if working from home would have an impact on your Social Security status. It was quite quickly concluded that it could have an impact, but we didn't want that. So as of July 1st, 2023, we have a specific arrangement. In Dutch, it's called the kaderovereenkomst. That in cases of teleworking, so if you work from a laptop, simply put, upon request of the employee, you can work from home, or at least your home country, up to 50% of the time without having any impact on your Social Security place, which is always good. I always like to point out the potential outcomes, because it's different than from the taxation. It's black and white. There's no gray situation. You're either subject to Dutch Social Securities or not. It goes for your whole income. So if you look back at the tax rates that I said, if you would come to the conclusion based on the Social Security contribution legislation that you're not subject to Dutch Social Security, but you would have income taxable in the Netherlands, in box 1, you would only pay the 9% tax. You can also have the situation the other way around. In Holland, we know the A1 declaration. I've assumed that's something that does ring a bell. If not, please let me know. But the A1 declaration is like a permit or a provided information where you're subject to Social Security. And then we're up for Dutch labor legislation.
Yes, thank you, Susanne. So I'm Kyra van Denken. I'm a labor lawyer at Baker Tilly. And today I'm take you through the most important parts of employment law. However, as you can understand, there are many more rules and exceptions. So if there are any questions, please ask them in the Q&A. So the basic principle is that employment contracts are entered into for indefinite period of time, unless otherwise is agreed. However, practice shows that employers first offer a fixed-term contract before entering into a permanent contract. I will talk you more about the possibilities of a fixed-term employment contract in a moment, but the reason why employers choose a fixed-term employment contract is because the employer can first see if the employee meets the desired requirements of the position. It is possible to agree a probation period, but in the Netherlands, only a relatively short probation period can be agreed upon. I know this is quite different in the UK, so please, if you have any questions about that, ask me later. Because in the Netherlands, an employment contract for an indefinite period of time, there can be a probation period up to 2 months can be agreed upon. So in case of an employment contract for more than 6 months, a probation period of 1 month is possible. But the main difference between a fixed term and a permanent employment contract is that a permanent contract is not easy to terminate in a certain period of time. To end an employment contract, an employer should have a reasonable ground for a dismissal. And this reasonable ground must be substantiated in written. These reasonable grounds are limitative, and I give you some examples. So we have the business economic reasons. So if about financial reasons, we have the long-term illness, and this is after 2 years of illness. I will tell you more about that later. But also dysfunctioning, a disturbed working relationship, or culpable actions. If you as an employer cannot substantiate probably one of these grounds with documentation, then the UWV, that's a government agency, or the court will not grant permission to dismiss an employee, which means you cannot dismiss the employee at all. So first, to dismiss an employee, you need permission of the UWV, or that's a government agency, in case of business economic reasons or in case of long-term illness. And otherwise, the court must dismiss an employee. So only in case of an instant dismissal, you can dismiss the employee immediately. But in practice, because it's very difficult to dismiss an employee in the Netherlands, employment contracts are mostly terminated with a so-called settlement agreement. However, a settlement agreement requires an employee's agreement. So if you don't have a good file to dismiss an employee, the willingness of an employee to agree with a termination will decrease, or it can result in a higher compensation. So with a fixed-term employment contract, dismissal rules apply, but a fixed-term contract will end by operation of law on the agreed termination date. So this is why a lot of employers in the Netherlands first choose for an employment contract for a definite period of time. So the fixed-term contract, and this can be entered into because for a duration of a certain period, but also for because of replacement of a sick employee or a sick colleague, or based on a project. But as I mentioned before, the main reason is that employers don't want to be immediately stuck with an employee for an indefinite period of time. So it is possible to enter into, in total, 3 fixed-term employment contracts in a period of 3 years. You can go to the next slide, Susanne. After the 4th employment contract, or if the employment contract has lasted longer than 3 years, the employment contract is for an indefinite period of time automatically. So, for example, if you can enter into a 3-year contract, but it is also very common in the Netherlands to first enter into an employment contract for 7 months. So why 7 months? Because with a 7-month employment contract, a probation period can be agreed upon. With a 6-month employment contract, that is not possible. After these 7 months, you can offer 2 more fixed-term employment contracts for a total duration of 29 months. What is also important if you have a fixed-term contract is that there is a notice requirement. This means that you have to give notice to the employee in written. What is this? This is just that you have to inform the employee no later than 1 month before the end of the contract if you want to extend the contract or not. And if you want to, under which conditions. If you don't do this, the employee can claim a notice penalty. This notice penalty can be 1 month's gross salary if you fail to give any notice, and a pro rata amount equal to the number of days that you are too late to give notice. Please note that this also applies if you want to renew a contract. So you will renew a contract, everybody is happy, but you didn't give notice, the employee can still ask for, can still claim this penalty. So please be aware of this and don't forget to do so. Then the collective labor agreement and the mandatory pension funds. So based on Dutch law, an employer may be obligated to apply the provisions of a collective labor agreement or join a mandatory pension fund. It is very important to check this before you want to hire staff in the Netherlands, because if you do not follow a collective labor agreement or the correct pension fund, this can cost you a lot of money. If a collective labor agreement or a pension fund is applicable, it depends on the industry or the sector where the company is operating. So if a collective labor agreement is applicable and it's applicable to more than 70% of the Dutch employees, the terms of the collective labor agreement can overrule the terms agreed in the employment contract. So we recommend to always verify this before you are hiring staff. The mandatory pension funds, there are more than 50 of them. This is it's a bigger risk, because if you don't offer the employees a pension at all, or you offer the wrong pension, a pension fund can claim up to 20 years back of contributions. So, for example, we have a big I won't say the name, but a holiday company that had to pay for 20 years of contributions, and it's a significantly big amount. So please always check this. You can always ask us if we can check this for you, but it's all based on your industry, the industry of the company. So then I will tell you a little bit of the terms of employment. First of all, in the Netherlands, we have, as well in the UK, a minimum hourly wage. This minimum wage will be revised every 6 months by the government. So the currently hourly wage for people that are 21 years or older is €13.27. This amounts like £11.50. So basically, parties are free to agree on the amount of the wage. However, if there is a collective labor agreement that applies, as in many industries, a higher minimum wage can be agreed upon. But also we have some industries, for example, in the transport industry, that in the collective labor agreement, there is also a maximum of the hourly wage. So you can see already that it's important to check if there is a collective labor agreement. Then we have the holiday allowance and the holiday leave. The holiday allowance, every employee in Holland is entitled to a holiday allowance. This is 8%. So it doesn't matter if you have a fixed term or a permanent contract, or if you are an on-call worker, it doesn't matter. The allowance, the employee is entitled to this allowance. This allowance is built up over the actual salary of an employee. And you can choose if you want to reserve this holiday allowance each month and pay it out in the month May or June. So employees can go on holiday in the summer, or you can also choose to pay the holiday allowance directly every month. You see with on-call workers that employers pay it every month and don't reserve it. But besides the holiday allowance, we also have the holiday leave. And we have statutory leave and non-statutory leave. And the statutory leave is 4 times the weekly working hours. So in case someone is working for 40 hours, they have 20 statutory holidays. The non-statutory holidays are mostly in collective labor agreements. There are non-statutory holidays stated. So in practice, we see that employees are entitled to 20 statutory holidays and generally to 5 non-statutory holidays. And in addition, employees are also free and receive payment on national holidays, which are the bank holidays in the UK. So if an employee, if Christmas falls on a weekday, this employee also gets this day free and get paid on that day. So illness, sickness, this is very different than in other countries. And always when I tell this to, for example, especially to clients from the US, they are often in shock. But first of all, every Dutch employer is obligated to have a contract with an occupational health and safety service. This is because if an employee falls sick, he must be seen by the company doctor. Here I'd like to note that only a company doctor can decide whether or not an employee is unfit for work. So not the employer, not the employee, and also not the employee's general doctor can say this. It's just the company doctor then that can decide this. Besides that, the employee and the employer are both responsible for reintegration for 2 years. They must follow all the advices of the company doctor up to 2 years. So as an employer, if an employee is sick, you are not allowed, there is a ban on to dismiss an employee for 2 years. And you have to pay wages for 2 years as well. Since this is quite a lot of money that you have to pay, like you have to continue the wages for 2 years, there are some insurance that you can take for to cover this. But please keep in mind that this is not very cheap. So this is something you should be aware of. So what is the payment of wages during illness? So first, during the first year, an employer is at least obligated to pay 70% of the salary with a minimum of the statutory minimum wage. So if the employee already earns the statutory minimum wage, you have to pay the employee 100% of salary the first year. During the second year of illness, there is a minimum of 70%, regardless the statutory minimum wage. However, keep in mind that a lot of collective labor agreements stipulate that an employer must continue to pay 100% of the salary during the first year. And also in most collective labor agreements, it's stipulated that they have to pay 80 or 90% also during the second year. So this can be very different if you fall under the scope of a collective labor agreement. So when an employee gets sick, it's important that a company doctor decides whether or not he is sick. He gives the advices, and if you're both the employer and the employee must both follow these advices. There are certain sanctions if, for example, a wage sanction as a suspension or stopping of the salary if the employee does not cooperate with the advice of the company doctor, but also if the employer is not cooperating with the advice of the company doctor, or if he does not remind the employee to follow the advices, then the government can give a 3rd year of a wage payment to the employer. So it's important to make sure that an employee knows what the rules are during illness. So please make some agreements about this. It should be clear to the employee what is expected from him, and so he must be always, for example, report sick personnel in person. He should always provide his nursing address, and he should always cooperate with the advices of the company doctor. That's the next sheet. Yes. So please keep that in mind. So the last part, then everybody can enjoy their evening, is the permits. Side note is that we have colleagues who are specialized in work permits, since this is a very specific knowledge. But I will tell you a little bit about this. So when is someone allowed to work in the Netherlands? That are employees with a Dutch nationality, of course, and also employees that have the nationality of the European Economic Area and from Switzerland. So they don't need a work permit. Since the Brexit, employees from the UK are not allowed to work without a work permit anymore. But there are 3 types of working permits. This is the highly skilled migrant permit, the intra-company transfer, and the holder of a EU blue card. The most common one is the high skilled migrant permit, but there are specific conditions that must be met. So it requires that an organization has a registered office in the Netherlands. The company also must be a recognized sponsor. This can take a while to become a recognized sponsor. And there are minimum wages that you have to pay to these employees because they are highly skilled migrants. So for the highly skilled migrants over 30 years old, the minimum wage is 5,331 euros per month. So if you have the intention to send employees from the UK, for example, to the Netherlands, then a work permit is required. But there are, my colleagues told me, there are special exceptions that are made between the UK and Europe and the Netherlands. But this depends on the specific case and also on the industry and the branch that the company is has the activities in. But please feel free to contact us if you have any question about this. We're more than happy to help you. So these were a number of main rules from the Dutch labor law and also the tax law. And if you would like more information or intend to set up a company in the Netherlands, you can always contact us.
Well, thank you very much, Kyra and Susanne, for fantastic explanation of labour tax and labour law in the Netherlands. And thanks everyone for joining us. And I hope you got something out of it. My philosophy is if you've got one little nugget out of an hour spent here, then it was time well spent. And I hope we do think that your time was well spent. So thank you very much. If you've got any suggestions in the future for other topics for webinars or other videos that we can provide for you, then please let us know. And with that, I'd like to say thank you very much and goodbye until next time. Goodbye.